are here for the business panel. We have three terrific folks who are involved in a huge amount of this litigation or reporting on it. Greg Stohr with Bloomberg News has covered the court for many years with a particular focus on business cases and all of the major litigation at the Supreme Court. Well, Kannon to my right, Ed Williamson Conley, former assistant to the Solicitor General, has developed an extraordinary practice in private practice over a very short number of years, and Phillips is really the leader of the private Supreme Court bar, and also now the managing partner of Sidley and Austin. Brandon would have now that it is now a multinational conglomerate as well. It has its own antitrust problems that we'll discuss in this panel. And what we've done is divided the business docket, which has a substantial number of cases in it, into 6 different segments, and each of these folks is responsible for 2. So we're going to do 2 rounds, and we're going to keep it moving. And Carter's going to discuss the court's class action cases.
Yeah, I think actually this is probably not the. I apologize in advance. I'm trying to get over a cold, so if I sound a little raspy, it's because I am a little raspy. But I think the class action cases are probably the most important cases on the court's docket this term, or at least carry the potential to be so.
In the business cases.
In the business cases. You know, 2 terms ago, the court decided Walmart. Prior to that time, I think I've been in these programs for a number of years, sort of moaning about the fact that the court was not considering class action at all. We had been bringing what I thought were quite significant class action issues to the court's attention for a number of years, and they kept getting cert denied, and cert denied, cert denied. And I think Walmart basically sort of posed the issue in a way that was almost unavoidable for the court to take it with an enormous class of 1.6 million women, and the classes that, you know, some of the supervisors were also members of the class of employees, and it was just a mishmash. And at the end of the day, what the district court was going to essentially litigate that on the basis of a formula. You could litigate what variables to put in the formula, but you couldn't actually litigate what individuals were going to, whether there was in fact liability for the individual. You're just going to punch it in and then fetch a number. And all 9 of the justices recognized that that's not how litigation works. And so that part was easy. Then the court, in what will become the much more important part for this term's cases, splits 5 to 4 in analyzing the commonality question. I made references yesterday in terms of the glue factor that Justice Scalia relied upon, and saying how closely connected are the issues in a particular case, and if there's enough glue, then you can go forward with it. If there's not, you can't. I always like concepts like that because they almost guarantee additional litigation. But what the court really did, which was very significant, is that there had been this long time, this old case, Eisen, that basically said, look, you can't decide the merits of the class action in connection with deciding the certification issue. You got to keep those separate. And so you had this, what at least in my mind was this kind of remarkable inconsistency that you had. The district court is admonished it has to engage in a rigorous analysis, but can only take a little peek. So these are kind of rigorous peaks. And I'm not even sure what that means in the scheme of things. And the law kind of developed for a very substantial period of time with this kind of uneasiness about what do you do with the merits, et cetera. And one thing that the majority said in Walmart that's pretty important is it said, no, you can get to the merits. A lot of times the merits are inextricably linked, and when they are, that's how you decide it. And indeed, in Walmart itself, the court really decided significant Title VII issues as part of deciding whether or not the class could be certified in that case. So it's against that backdrop that the court's now granted 2 cases, and of the 2, the one, at least to me, is the most interesting, is the Amgen case, which is a securities case. And it's not the 23A commonality issue, it's the 23B3 predominance issue. And it arises out of alleged misstatements that Amgen made about a product that it was marketing to treat anemia. And there are 4 different statements, one about how serious the risks were being analyzed by the FDA, and statements about what they do with off-label use and on-label use, et cetera. The issues in the case is not whether those statements were false or misleading or not, but the question is whether or not everybody in the market relied on those statements in deciding to purchase the Amgen securities during the period of the class that's alleged in the complaint. And We know from Basic versus Levinson that you have a fraud on the market theory and securities cases, which allows you to presume reliance if the information would likely affect the market price, and therefore you can assume that everybody who bought based on that price relied on the price, and then therefore indirectly relied on the misrepresentations that led to the price being at a particular level in a particular case. And so the question is, and then the question in this case was, but how do you know whether the reliance can be presumed unless you make a determination as to whether the statements themselves were material, that is, that they would affect the market price? And does Amgen have an opportunity to sort of rebut the presumption by showing additional evidence that there's simply no causal connection between the statements and the way the market operated under these circumstances, or at least put on evidence to that effect? It is to me at least, an exquisite case in terms of this overlap between the merits and the class certification issue, because it's absolutely clear that if you decide that these statements are not material, you're done. Nobody has a case left over. So that, to the extent that that's what the court was worried about in Eisen, and maybe still worried about, that's going to be, I think, a serious concern to the court. On the other hand, it does seem as though the majority of the justices in Walmart were perfectly comfortable with that. And of course, forcing the case to be litigated on those terms earlier rather than later does have the effect of what I was talking about yesterday, which is to end litigation sooner and to take away the enormous hydraulic pressure effect of class certification on settlement that otherwise exists. So this is a court that, generally speaking, distrusts litigation, and particularly big litigation, as a method of resolving matters. And so if I were going to bet, I would bet that the court's going to ultimately say that this analysis of materiality is an appropriate way to go in that particular case. The second case is the Comcast case, which is an antitrust dispute. It's a kind of a strange antitrust case. Comcast, obviously, a cable company, and they basically engage in what is clustering. So they trade franchises with different people, I guess, like trading cards in baseball. And eventually you end up with enough of a cluster of franchises for a particular area, according to the theory of the plaintiffs in this case, that you were so big that you deter others from wanting to sneak into your particular market. And those are called overbuilders. I don't know where these terms come from, but I'm sure there's some pretty significance to that. And so that was the only theory of antitrust liability that survived the way the district court analyzed the case at the motion to dismiss stage. And so the court went ahead and certified it on the basis that there was a damages expert who testified that he had done a comparator analysis of 6 other counties that had certain characteristics, and then compared to the Philadelphia metropolitan area. And if you do a regression analysis, what pops out of it is that the differential in price can be attributed to what would have been antitrust or anti-competitive conduct. The defendant, not surprisingly, suggested that that analysis is a complete waste of time and effort, that it doesn't remotely satisfy any of the notions for expert testimony under Daubert. That's one of the issues in the case. But the other issue in the case, which in some ways seems to me sort of less important but kind of more compelling, is that the expert's analysis really seems to go, it assumes, frankly, that there's just a complete anti-competitive activity going on inside Philadelphia, which is very hard to reconcile with the record in this particular case, since all you have is this deterring overbuilder theory as the basis for liability, and the expert conceded that he can't allocate or disaggregate that portion of the case. But so I mean that would be the easy way, or at least if I were deciding the case, to say, well, this is silly. My guess is the court will probably ultimately decide the Daubert issue, and then and analyze whether or not a district judge has to decide whether or not the testimony satisfies the standards of Daubert before it can certify the class. And my guess is the court will say that yes, that's part of the rigorous analysis that the court has to undertake.
Thank you. Ken, with antitrust law?
Sure. Well, first of all, I should say, since this is my first speaking appearance at the conference, and it's a great pleasure to be here. This is my first time here, and this has been at least a to date, a very interesting program. You may have a different view after I'm done talking about the cases that I have on this panel, though I think that each of them is not without its own interest. Antitrust is one of those areas of the law in which the Supreme Court has actually been relatively quiescent over the last 8 or 10 years. I argued an antitrust case 4 or 5 years ago on the appropriate standard for predatory bidding claims, and just to sort of state the question presented is perhaps to illustrate its narrowness. The Supreme Court has resolved most of the big issues in the area of antitrust law, but has really just simply not heard very many antitrust cases over the last few years. And this year, the court has one antitrust case already on its docket with another one on the way. I'd say that the questions presented in these 2 cases are relatively narrow, but of enormous practical significance to the industries involved. So let me talk first about the case that is already on the court's docket, and then I'll talk about the case that's on the way. The case that the court already has is a case called FTC versus Phoebe Putney. Phoebe Putney is not a British aristocrat. It is, in fact, the name of the company that administers a local hospital in Georgia. The hospital is actually the Phoebe Putney Memorial Hospital. The party to the case is Phoebe Putney Health System Incorporated. And this case involves the state action doctrine. It's a somewhat different doctrine in the context of antitrust law from the context of constitutional law. It's a doctrine that dates to a Supreme Court case by the name of Parker versus Brown, which was decided in 1943, which makes it almost positively Paleozoic by the standards of antitrust law. But this is a doctrine that essentially creates an exemption from the federal antitrust laws where the state is the relevant actor. And in some sense, the question in this case is whether the state is in fact the relevant actor here. The facts of the case are almost impossibly complex, and to avoid causing all of you to run to the exits, I'll try to just summarize them very briefly. This is a case that involves a municipal authority that was created in order to run the Phoebe Putney Hospital. So it's an authority by the name of the Albany County, Georgia Hospital Authority, and it was created pursuant to a state law that allowed municipalities to set up authorities to run hospitals. Well, this authority, the Albany County Hospital Authority, largely delegated the responsibility for running this hospital to 2 subsidiaries. They're effectively subsidiaries, of which one is the named respondent, Phoebe Putney Health System. And as it turns out, the local authority essentially sort of ceased to have any meaningful existence. The local authority had no employees, it really had no budget, and the hospital was being run by this private entity, the Phoebe Putney Health System, and the local authority held a reversionary interest, but for all practical purposes, this authority was a private, this subsidiary was a private actor. And what ended up happening was that this entity, the Phoebe Putney Health System, ended up purchasing the sort of nearest thing to a rival hospital, a neighboring hospital called Palmyra Hospital, and it purchased it basically from HCA, one of the largest private healthcare providers in the country. And so the question in the case is, in essence, whether this entity is imbued with the protections of the state action doctrine. And the Federal Trade Commission, in its brief, basically argues that it should not be, and therefore that it should be subject to the antitrust laws, really for 2 reasons. First, that in the state law there was really no clearly articulated state interest to displace competition. The state law was really created with the goal of just sort of allowing localities to administer hospitals, and there was no sort of broader purpose to displace competition. And the argument by the FTC in this case is that competition in this region was really displaced because once these 2 hospitals were brought under the aegis of a single entity, they held an enormous market share, not just in the localities in question, but in the surrounding area. And the FTC argues that there's no evidence that Georgia's intent in passing the local hospital authorities law was to displace competition. Second, the FTC makes the argument that there was really sort of no active supervision by the state of the activities of this entity, the Phoebe Putney health system. The argument was in essence, the argument the FTC is making is in essence that this entity, the local hospital authority, is simply a shell. It has no employees, it has no sort of active corporate being. The argument that is going to be made in response, and the responsive brief has not yet been filed, but I suspect the argument that's going to be made in response is that under the state action doctrine, you really shouldn't sort of peer into the relationship between the local hospital authority and any subsidiaries or corporate affiliates, but that once the state law sort of sets up these authorities, the inquiry is at an end. Now this is a relatively narrow question, but it may have implications for other industries in which localities set up kind of supervising entities. So, with regard to, for instance, a lot of the public utilities, you often have sort of similar analogous entities that are established pursuant to state law, and I suspect that there will be a fair amount of amicus activity from entities and interested parties in some of these other industries. But I think what will be interesting sort of more broadly about this case is that the Supreme Court has taken a sort of relatively expansive view of the scope of the state action doctrine, and the government has attempted in a number of contexts without much success to suggest that it should be viewed more narrowly. Certainly the FTC here is taking a fairly aggressive view of the requirements that have to be satisfied before the doctrine can be invoked, and it'll just be interesting to see how the court reacts to that. I think that the other antitrust case that is on the horizon is potentially more interested, and of course I would think that because I'm involved in the case. It's a case that the Supreme Court has not yet taken on the question of whether so-called reverse payments in the pharmaceutical industry violate the federal antitrust laws. And this is going to require a little bit of wind-up, but again, I will try to keep it relatively simple to avoid the flight to the exits. This case involves settlements of patent litigation between brand name pharmaceutical manufacturers and generic pharmaceutical manufacturers. And what makes this a little bit complex is that it involves the interplay between the federal regulatory regime for those manufacturers, which is of course administered by the Food and Drug Administration, and the patent laws, which of course apply across the board regardless of the relevant industry. All of that is governed by a statute known as the Hatch-Waxman Act. And in essence, the Hatch-Waxman Act provides a mechanism whereby disputes about the validity of patents held by brand name manufacturers can be resolved at a very early stage of the FDA approval process. So in essence, the statute creates a mechanism whereby when a generic manufacturer applies for FDA approval for a generic equivalent to an already approved brand name product, the brand name manufacturer can initiate litigation concerning the validity of its patents. And what is significant about this regime is that it really permits the litigation to take place before the generic manufacturer has even manufactured the generic version of the product. Now, these cases are often settled, as patent litigation often is, but the settlements look a little bit different, in large part, in our view, because of the nature of the regulatory regime. So what typically takes place is that when a brand name manufacturer settles with a generic manufacturer, the settlement involves so-called early entry, and of course whether or not it's early depends on your view of the underlying patent litigation, but in essence what takes place is that the brand name manufacturer agrees to permit the generic manufacturer to enter the market before the generic manufacturer otherwise would be able to do so given the patent which the brand name manufacturer holds. So if the brand name manufacturer holds a patent that would be valid for an additional 8 years, it might agree to permit the generic manufacturer to enter the market 2 years early. What is being challenged in this litigation is a practice used in some pharmaceutical settlements of the brand name manufacturer making a payment to the generic manufacturer. So often, in addition to permitting the generic manufacturer to enter the market at a particular date, the brand name manufacturer will agree to pay some sum of money to the generic manufacturer.
A little sum or a big sum?
Well, it depends on the particular case. We would certainly make the argument that the sum in our case was modest and supported by additional consideration, but I realize that some might disagree with that, including possibly Tom, who is involved in the case. So, and what makes this a little bit different is that in typical patent litigation, it is actually the alleged infringer who will often make a payment to the patentee as part of the settlement, because the infringer. Well, the alleged infringer in most patent litigation will have actually started to manufacture the product at issue and therefore caused monetary damage to the patentee, whereas in the context of pharmaceutical litigation, nothing has yet been manufactured. The government has challenged settlements of this variety for a number of years, with the FTC in particular taking a fairly aggressive view on the issue, but at least to date without much success. And lower courts had typically held that as long as the settlement is within the scope of the relevant patent, the settlement passes muster under the antitrust laws. That changed when the Third Circuit held that so-called reverse payments are presumptively invalid, that they constitute prima facie evidence of invalidity in the case in which we're involved, a case known as the Cater case, but which is now known in the Supreme Court as Merck versus Louisiana Wholesale Drug Company.
And Kannon versus Tom.
And also Kannon versus Tom, to the extent that the lawyers matter in any of this. So we filed a cert petition for Merck back in August. The response has not yet been filed in that case, but the chairman of the FTC has indicated that the FTC may be seeking cert in a case of its own, which came out the other way from the 11th Circuit. I think it's virtually inevitable that the Supreme Court is going to grant review in at least one of these cases, and that it will likely hear at least one of these cases this term. It could not be clearer that there is a circuit conflict on this issue. Indeed, the FTC had actually previously argued that there was a circuit conflict even before the Third Circuit's decision. The Third Circuit goes into some detail about how it is creating a circuit conflict in its decision, and it's a very interesting case. We, of course, think we have the better of the arguments on the merits, but the Supreme Court has really never opined directly on the potential antitrust limits of settlements, at least in the context of the pharmaceutical industry. And this is an issue that, again, has been litigated for many, many years, and looks like it's finally going to find its way to the court.
You want to write a
Can I ask you a question though, Ken? And does the FTC have independent litigating authority as a court? And is the Solicitor General going along with them, or do you know?
The FTC does have independent litigating authority in the court, and this was perhaps famously illustrated in one of the prior cases, actually one of the prior rounds of litigation in this very case, in which the 11th Circuit actually held that the very settlements at issue in our case were valid in an FTC administrative proceeding. The FTC actually filed a petition for certiorari in the Supreme Court at that earlier stage, and the Supreme Court, perhaps recognizing that the FTC has independent litigating authority and recognizing that the Solicitor General was not on that petition for review, actually called for the views of the Solicitor General in response to that petition. And the Solicitor General promptly filed a brief in which it said that cert should be denied, which probably created some discomfort at joint FTC Justice Department cocktail parties, because the Justice Department had typically taken a somewhat different view on the appropriate standard for reviewing these settlements. And of course, by the Justice Department, I really mean the Antitrust Division, which of course, along with the FTC, has joint authority to enforce the federal antitrust laws, or at least has its own a share of that authority. The FTC and the Justice Department, at least since January of 2009, seem to have made some effort to kind of cause their merits positions to converge. It will be interesting to see if they in fact converge in the Supreme Court. The FTC and the Justice Department actually filed separate briefs taking somewhat different positions in the Third Circuit. They brought in the Deputy Solicitor General to present oral argument, and he did so on behalf of both entities. So there does seem to be a considerable effort being made within the government to actually come up with one position on the merits. We'll see if that turns out to be the case.
Greg, do you want to do employment and discrimination questions?
Sure. Actually, one thing I'll do, Tom, is I'll do employment and ERISA here, since ERISA begins with employee. I won't spend too much time on ERISA, because that will be worse than antitrust. So the big employment case that the court has this term is a case called Vance versus Ball State. And it's a follow-up to back in 1998 when the court decided a pair of cases where they said that employers can be liable for harassment by an employee either vicariously in the case of a supervisor who harasses somebody who works under him or her, or through ordinary rules of negligence if it's a coworker who's doing the harassment. And the follow-up question in this case is, what constitutes a supervisor? A lot of us work in places where it is not always that clear exactly who is our supervisor, and in the case before the court, it's one such situation. So the woman who worked in the catering service, essentially a kitchen worker, it seems, at Ball State University, she complained about two co-workers, one of whom was arguably her supervisor. The woman who sued is black, and it was racial harassment she was alleging. There were all sorts of allegations of racial slurs. Unquestionably, it's at least two employees who don't get along very well. Whether it was actual racial slurs is still a dispute. But for the court, the question is whether this other woman is actually her supervisor enough that it kicks in vicarious liability and makes it easier for Ms. Vance, the plaintiff, to win her suit against Ball State University. The lower courts are divided on what the standard should be. In this case, the Seventh Circuit, I believe by itself, I believe it's the only circuit that has this standard, essentially said to be a supervisor, you have to have power to hire and fire, and you have to actually have authority over the terms of employment of that person. Other federal appeals courts have said that it can be enough that you control the activities of the person. And in this case, Ms. Vance says, the woman I'm complaining about, who is my supervisor, was actually the one who told me whether I was chopping celery that day or doing something else. So she says she ought to be able to win her case with only showing that the employer was negligent and not doing enough to take care of the problem. The respondents haven't filed a brief yet. That's due on October 19th. The Solicitor General has filed a brief that, and seems like in a lot of cases, this term sort of splits the baby a little bit. They say we agree with Ms. Vance on the standard, that it shouldn't just be somebody who hires and fires, who is your supervisor for the purposes of harassment law. But in this case, there's just not enough evidence that Ms. Davis even controlled the daily work activities of Ms. Vance. So she should lose the case regardless. Last night there was a little bit of discussion about whether or not this is a pro-business court, and I'm sure the people on this panel will have some views on that. I know Carter said some things last night. Employment is an area that has been, even if you're a believer that this is a pro-business court, employment law is not the area where that comes out. It's an area where oftentimes the employee will win the case. So it is by no means a sure thing that the employer will prevail in this case just based on that. I'm going to turn briefly to the ERISA case. It is actually more accessible than the usual ERISA case. I'll try to describe it quickly.
That's a very low bar.
It's like it is like being the tallest skyscraper in Topeka, I suppose. So this is a case about a man who was in an automobile accident, very serious. A number of people were hurt in the accident. I think some may have been killed. The driver of the accident who was responsible was underinsured. He says his harm, the damages he suffered, and he has a variety of injuries, were upwards of $1 million. But he settled the case with her for a total of $110,000. That was $10,000, excuse me, settled the case, period. $10,000 from her directly and $100,000 from his insurance company under his underinsured motorist provision in his plan. Along the way, he racked up some medical bills that he's a U.S. Airways employee, and his health plan paid for $6,000. In his plan, as in a lot of plans, no doubt mine and probably most of us here, there's a provision in there, a so-called subrogation clause, that says if you incur medical expenses and you recover those expenses from a third party, as Mr. McCutcheon did here, you have to pay us back the medical expenses. And so U.S. Airways sought to recoup the $66,000 from Mr. McCutcheon and pointed to that clause. And it's undisputed that under the terms of the plan, he has to pay that money. But at the lower court level, at the Third Circuit said that it would use its equitable discretion, the general equitable discretion that courts have to say that it would be unfair for U.S. Airways to recover that money, especially since to get that $110,000, he had to pay his lawyers a 40% contingency fee. I believe actually it's only 40% of the $100,000, although I could be mistaken on that. So he shouldn't have to, and he actually ended up getting less than $66,000, so he shouldn't have to pay back U.S. Airways. And so the legal issue in the case is whether judges can use, under ERISA, whether they can use equitable principles to basically rewrite contractual language. Again, the U.S. Airways says no, McCutcheon says yes. Again, the Solicitor General comes in with a middle ground, and this one may well have some appeal for the court. The SG says, as a general matter, no, you can't. But when it comes to attorney's fees, you can at least there use your equitable powers to determine how those will be paid. So there's at least a prospect that Mr. McCutcheon won't have to pay back the entire sum of money.
Terrific. We're going to turn to our second go through the panelists, this time more quickly with sort of a smaller set of cases, and Carter's going to do IP.
IP. Well, I did want to say, since this is a journalist, lawyers, academics thing, I have my favorite ERISA stories, which is a real short one, is when I was arguing a case called Pegram several years ago. Linda Greenhouse called me up and asked me to explain what the case was about without using the word ERISA. IP, you know, when this program started 25 years ago, there would not have been a segment for intellectual property because the court virtually never took an intellectual property case. Those who've been at this for a while know. I use this story a lot, that when I was clerking, it was enough to say to the court in a pool memo, this is an intellectual property case, I'd recommend deny, and that would get it done. You get a nasty email, or I guess not in those days, you get a nasty memo or a law clerk from Justice Blackmun coming in saying you weren't taking the case seriously, but other than that, the court wasn't going to touch that stuff. And as Joe Muscubic said to me yesterday, I've now made a career out of intellectual property because it's become the sort of the hottest topic out there. Last term was no exception, and we'll see how it plays out this term. There are no sort of blockbuster intellectual property cases. Immediately, I'll talk a little bit about one of the sort of soft IP cases that is there that's kind of interesting. And then I have a couple that I'll identify as one that I think the court might take and one that clearly the court won't take, but raise an issue that I'm pretty sure the Supreme Court's going to have to resolve at some point. The soft IP case is Kirstang, and that's a copyright case, and it's a reprise of sorts of the Costco case that the court affirmed by an equally divided court a couple terms ago when I guess Justice Kagan was out. And so you sort of go in assuming it's going to be a 4-4 split. You know, the situation is pretty straightforward. This is a kid who's from Thailand. He's getting his education in the United States. He figures out, geez, you know, if you cost the books, it's really extraordinary in the United States. You buy the same book printed in English in Thailand, it costs about half what it costs here. So just to have my parents ship me over a batch of those books from John Wiley and Sons, and I'll sell them on the secondary market and do okay. And I think he made about 37 grand doing that. John Wiley and Sons' head exploded, not surprisingly. And I said, wait a second, you can't.
John and the Sons all
everybody's all of the heads everywhere. It was.
The question is, how do they find out about this?
Well, I think when we go to the tune of $37,000, I mean, at some point you just sort of open and notorious.
Yeah, he probably had the misfortune of setting up a website or something.
Yeah, I suspect he did. In any event, it ended up, you know, he loses his case. The damages are about $670,000, and this is a great line in the brief about how they took away his golf clubs. I mean, it's just, I'm just tears. Anyway, so but it's a very interesting, and this is one of those classic situations where Congress has been less than clear in how it has articulated the appropriate rule in this context. Because on the one hand, you have the first sale doctrine, which says if you got a copyright, you sell it, you're done, you've exhausted your rights, move on. And then there's another provision that talks about importation and seems to at least grant an extraordinary amount of protection to the copyright owner in the importation context. And the question is, how are you going to reconcile these two? And in some ways, there is no easy solution to this particular statutory problem. Any interpretation will create some kind of glitches in it. I have to say that the argument that, at least from my perspective, carries the most weight is that the way the Second Circuit has interpreted this, which is to say, if you manufacture abroad, then you basically get off the hook on, you get complete copyright protection no matter how much you sell, or how many steps downstream you sell this thing. It does seem to me an extraordinary incentive to take all of the business of the United States out of the United States in order to ensure significant copyright protections in a way that you otherwise cannot get in the United States. But it was a 4-4 decision the last time, so it's tough to it's a tough one to predict. Although if I had to predict, I'm going to say that they're not going to adopt that rule. And then the intellectual property cases, the one that I thought the court might have granted on Tuesday was a case called R.J. Reynolds versus Stohr Scientific. Fortunately, the court didn't grant that one because the case went away. I can't tell you too much about that. I represented Stohr Scientific. The case went away, but I can tell you that the legal issue in that case, which is the indefiniteness doctrine, which is a requirement that claims and patents have to be stated with sufficient concreteness to describe fairly the metes and bounds of what's being protected by the monopoly that the patent confers, is a doctrine that the Federal Circuit has essentially eliminated as far as I'm concerned, because the test of indefiniteness is insolubly ambiguous. And almost nothing is insolubly ambiguous, at least as far as I can tell. And so I think one of these days, the Supreme Court's going to revisit that issue and decide that. And I think they're going to decide that the test is something greater than insolubly ambiguous, but we'll have to wait for another day. And that's just as well, because I was on the respondent side of that case, and I wasn't looking forward to defending it anyway. The other case, which tracks an approach that I think is pretty interesting in general, which is that we've talked about this before, which is that oftentimes in intellectual property cases, particularly patent cases, the court asks for the Solicitor General's input on whether or not to take a particular case. And in the GlaxoSmithKline case that's up at the court on the issue of proper interpretation of Section 271C of the Hatch-Waxman Act, the court did ask for the views of the Solicitor General, and in that case, the issue is that's how the safe harbor operates. And Congress obviously wants to allow generics to infringe patents in order to allow them to come up with generic products, and it's the only way they can do it. So they have this exemption or safe harbor that says, under certain circumstances, if you're doing it this way just to test in order to create a generic, you're not subject to the patent statute. But the language, and it's clear that that's what this is aimed at. It is aimed at just protecting the generics. There's no question about that. But the language doesn't track that anywhere nearly as carefully. It's much broader, and the Federal Circuit now, and for the third time, has decided to engraft an atextual limitation on the scope of this particular provision. It's been reversed twice before, I think unanimously both times. And so but this time around what it said is the provision only applies to generics, and then it only applies prior to FDA approval. Well, neither of those limitations exist in the statute. The only thing that's an interesting spin on this is that the Federal Circuit then comes out with a decision in the interim in which one of the members of the majority of the Glaxo case is now in the dissent, and the dissenting writer in Glaxo is now in the majority with another judge. And they basically have said, well, that Glaxo case is good law up to the point of post-FDA, but just for routine stuff, because they took a single line out of the opinion and said that's the holding of the case, and therefore we can essentially gut every other aspect of the opinion. Not surprisingly, the dissenting judge is shrieking that that's not what we said in that case, but it creates probably more confusion than the Supreme Court will like in any particular issue. My guess is they'll wait to see what, if anything, the Federal Circuit will do on this issue en banc before it weighs in. Whether it'll hold my case for all that time or how they'll deal with it, who knows. But sooner or later, they're going to decide that issue because it's a mess.
Kannon, standing?
Well, Tom retaliated against me for having the temerity to take a contrary position on the reverse payments issue by assigning me the Article 3 jurisdiction cases on the court's docket, and if any of you are left by the end of this, I may be pleasantly surprised. There are two. Tom is involved in one of them. The first is a case, and I should just say by way of background for those of you who were here last night, I think that it's fair to say that the current Supreme Court, and really sort of all points on the spectrum on the current Supreme Court, have shown a kind of desire to devise ways of keeping cases out of federal court, whether it's pleading standards or rigorous application of jurisdictional restrictions. And I think both of these cases test that principle. And they both involve fairly similar issues. They both, at a very high level of generality, involve efforts by defendants to settle cases by giving the plaintiffs arguably everything they were seeking, and therefore to moot or otherwise end the litigation. The first is a case called Genesis Healthcare versus Smizik. Smizik is a person as well as a way of getting about 150 points in Scrabble. The question in the case involves a claim under the Fair Labor Standards Act. Ms. Smizik claimed that she was essentially charged for break time that she didn't take, for breaks that she didn't take, with the result that she was undercompensated, and she brought a claim against her employer for something in the neighborhood of $7,000. The Fair Labor Standards Act is kind of an odd duck because it actually does not provide for class actions. It provides for a different kind of breed of action known as a collective action, and it sets out processes, a process whereby you can initiate that collective action. So in her complaint, she brought suit on her behalf and on behalf of other unnamed, similarly situated individuals, but she did not trigger the kind of process. She did not initiate a collective process in the parlance of the FLSA. And so the defendant, faced with this lawsuit for $7,000, said, perhaps not surprisingly, we'll pay you your $7,000 and we'll even throw in attorney's fees to boot to end this litigation. And the defendant then turned around and argued that the litigation, when the offer was not accepted, that the litigation was at an end because they had provided a full offer of judgment under Federal Rule of Civil Procedure 68. And the question in the case, I think, will ultimately turn on whether the court views this as kind of more akin to a traditional individual action, where if you give the plaintiff everything the plaintiff is seeking, the litigation is pretty clearly at an end, or whether the Supreme Court will view this as sort of more analogous to a class action, where because of kind of limitations and other considerations, a full offer to the named plaintiff does not, in fact, end the litigation. So it's a kind of an interesting case for that reason. The other case is the case that Tom is involved in. It's a case called Already versus Nike, and it involves one of Nike's products known as Air Force One. Am I correct? I have to admit that Tom argues in his brief that this shoe has attained some level of cultural significance. He even includes a cite to a YouTube video. I have to confess that I was more of a Chuck Taylor man myself when I was growing up. No offense to your client, but I was kind of a Converse
We own
guy.
them too.
Yeah, I guess that's right. Yeah, Converse is now.
Advertise for us away.
I guess that's right.
Fine shoe.
I assume that the limitations period on any antitrust claims involving that merger has now since run. So, but in any event, a company by the name of Already produced a shoe by the name of Soulja Boy. I have to admit I'm not familiar with the cultural significance of that either, but
It's actually a person. Soulja Boy.
okay, excellent.
I'm hearing from him.
We'll look forward to hearing all about Mr. Boy, but in the meantime, the the case involves trademark protection because Nike obtained trade dress protection for the design of its shoe. And when Nike learned of Soulja Boy and the Soulja Boy shoe, Nike was not amused and it brought an action for trademark infringement. And in response to that action, already asserted a counterclaim claiming that the trademark in question was invalid. And that's pretty customary in trademark litigation as it is in patent litigation. Now, Nike decided to settle this case when the district judge in a preliminary hearing announced when he was presented with pictures of the two shoes that, quote, they sure look different to me. And Nike suspected that the writing might be on the wall. And so it provided to already and to Mr. Boy a covenant not to sue. And in that covenant not to sue, Nike said that not only would it not sue with regard to this particular design, the design of the Soulja Boy, but that it would also not sue with regard to any colorable imitations. And so the question before the court is, again, a question of mootness, whether this essentially essentially resolves the dispute between the two parties, notwithstanding the fact that already had this counterclaim of its own, claiming that the entire mark should be invalidated, which would potentially have consequences in the event that already attempted to market a similar product. And the argument that Tom makes, I think, not without considerable persuasive force in his brief, is that when you've got a covenant not to sue that covers not only the product at issue, but any colorable imitation, and where there is no indication that the company at issue already has any desire to produce a comparable product, that really ends the dispute between the two parties. This is another case in which I believe the Solicitor General's office has kind of tried to walk a middle line and suggested that there should be a remand for further factual findings. We'll see if that gets any traction with the court. But again, these are two interesting cases, and I think in a sense they are perhaps of a piece with the jurisdictional concerns that were raised yesterday in the moot court involving the Fisher case. There are some distinctions, I think, in terms of how the jurisdictional analysis should work, but these are all cases in which arguably the plaintiff has kind of gotten everything that he or she wanted, or at least been offered everything, and the question is whether litigation should nevertheless go forward in a federal court. Greg?
I'm going to talk about a case the court hasn't agreed to hear yet, but there's really good reasons to think it will. It has to do with whether disparate impact claims are cognizable under the Fair Housing Act. And the reason I'm pretty sure the court's going to take it is because they had a case last term that presented pretty much the identical issue, and it magically went away. Maybe not so much.
Perhaps not magically. I didn't believe the Wall Street Journal editorial.
Yeah, the case last term had to do with St. Paul, Minnesota, and the enforcement of its housing code, and landlords sued claiming that it was having a disparate impact on black tenants. And the Eighth Circuit said it's cognizable, so you could sue, and that's what every appeals court that has considered this for quite some time has said. Yes, there's you can sue, you can press disparate impact cases under the Fair Housing Act. The city petitioned to the Supreme Court granted cert. It was set up in a way, when the Supreme Court agreed to hear it, people sort of said, hey, well that's, there's no circuit split, why did you take that? Gee, it sounds like maybe the court's going to say disparate impact claims are not cognizable. At some point along the way, St. Paul dropped its petition, agreed to dismiss the case. The Wall Street Journal editorial that Kannon talked about had to do with what the Justice Department offered to the city of St. Paul to make the case go away. There are allegations that the Justice Department agreed to stay out of other actions, other lawsuits, including I think a False Claims Act case against the city in exchange for the city's agreement to drop its petition. Nonetheless, so that case went away, but now the very issue is back, and there's a good chance the court will agree to take it up, I would think. This case, the case that's this term, comes out of the town of Mount Holly, New Jersey, which sounds like a nice place, but apparently has one not very nice part of town that the city said was blighted and was a source of crime. This was also a heavily minority area. In fact, I believe it's the only majority minority area in the city. So the city said, we're going to renovate this whole area. They didn't do it through eminent domain. They bought up properties. But residents who didn't want to sell sued, saying the decision to basically destroy this neighborhood had a disparate impact on the city's minority residents. So the petition presents two questions: whether disparate impact is cognizable. If so, what is the standard? The second question, it seems to me, could be one the court does not take because, first of all, it may not need to get there if it says no disparate impact. But HUD is currently working on some regulations, and I think they've already gone through the notice and comment period on the question of what the standards are for disparate impact claims. And that could certainly muck up the court's analysis of that issue if it were to get to that. So there's a reasonably good argument, I think, that the court shouldn't take that issue. Again, in this case, it's an instance where, at least last term, the Solicitor General tried to cut a middle ground. They said that in that case, disparate impact claims are recognizable under the Fair Housing Act, but in the St. Paul case, at least, the city should win, that there wasn't enough evidence that the 8th Circuit had misapplied the formula for determining whether there was disparate impact, and there wasn't enough evidence that there was. This is a very big case for lenders. Lenders hate disparate impact liability under the Fair Housing Act, so they will certainly weigh in heavily in this case.
Redlining allegation.
Yeah. I don't think the court would get to this if anybody else wants to weigh in. I mean, this is just a statutory case, but when you think about disparate impact, at least I always think about what Justice Scalia said a couple terms ago about the evil day that he foresees when the court has to consider whether disparate impact claims under in that case, I think it was Title VII, can be squared with the Equal Protection Clause. So at least in the background is this question about constitutional standards as well.
It would be, if they do take up the Mount Holly case as a successor to that St. Paul case, it would be an extraordinary case, a term about race in the Supreme Court. If you take Fisher and the fact that they're going to take out Section 5 of the Voting Rights Act, certainly as has been discussed, and then on top of that have disparate impact liability under the Fair Housing Act. And all of those, you would assume that the court's direction would be in a fairly conservative trajectory. So it would be, that would be quite a collection of decisions in a single term. We have just a few minutes. If we could just see if anybody had any closing questions before we send you off to lunch, and note that you're holding everyone else.
Don't be intimidated, however.
Is there a circuit split on that FHA issue?
There's not. Every circuit that has ruled on it, I think it's like, all or almost all has said that there is disparate impact liability. There may be a little bit of a split, at least in the reasoning of how it applies, but not on the basic question.
All right, thank you all so much.